Mr. Schmidt, I understand you're ready. Now, Mr. Schmidt, I'm not hearing you guys at all.
He just unmuted. Can you hear us now? I'm gonna keep saying can you hear us now until we can hear us now.
I can hear Mr. Schmidt, so it may be on the court's end.
Yeah, I've got no audio.
And I turned up my screen. What did I do?
Yeah, Jonathan's gonna be over there to send it to.
Oh, he's talking about you. I can hear him just fine.
All right, Mr. Schmidt, I think just 1 second here. We're having. I think all the rain, it was raining in the courtroom earlier, so
Right here.
I think we might have a little bit of a glitch on our. All right, Mr. Schmidt, let's try it again. Got a little bit of a circus going on over here.
Yeah, we were getting seasick with the camera moving. Are we good? Can you hear me?
I can't hear you.
Okay, good. Who do you want first, Judge?
You tell me who you want first.
Harold Powell. Come on down.
All right, this is cause number CR 21-235, State versus Gerald Wayne Powell. Status. Dr. Proctor's report. I have a note.
That's correct, Judge. We received communication from Dr. Proctor January 18th, I believe. And he had indicated that he was set to meet with Mr. Powell for his final meeting. Mr. Powell indicated to me that meeting did take place as scheduled. Now, at this point, we're waiting on Dr. Proctor's report, which I don't believe that he's completed. So I can say, depending on the results of the report, once we review that, me and Ms. Curry have spoken about our next steps. It will determine which direction we go. So at this point, however the court wants to handle that, I think that in the event that the report from Dr. Proctor is unsatisfactory, we have retained an expert as well for the same purposes. I would like to believe it wouldn't take nearly as long, but I've informed Mr. Powell of that. We'll see how it goes. So as far as next settings are concerned, I'll leave that up to the court.
Give me a time estimate on what you think Dr. Proctor's likely to require to get his report done.
Judge, Dr. Proctor is a state's expert, but if past experience is any indicator, he does not move quickly. And so considering he had his final evaluation this month, I'd be shocked if we got it back within the next 60 days, but then again, I don't know for sure.
State, do you have any information about Dr. Proctor and how quickly we can get his report in?
Judge, I don't, Mr. Schmidt, right, past experience tells me not to expect it very soon. Judge, what I propose is that we reset it for 60 days. I will talk to Ms. Curry about contacting Dr. Proctor, see if we can get it faster than that. Mr. Powell is in custody, so if we do get it back faster than that, then we could always ask the court to move it up on the docket. But I don't expect it back very expeditiously.
And Judge, I would also tell the court that the court approved funds for an expert, a defense expert. So I'm holding off on letting him loose at this point because Dr. Proctor's results may negate the necessity for that. Previously, he couldn't start because Dr. Proctor hadn't finished. I don't know if you're following me, but we're trying to save the court's funds and not start that process if it's not necessary, but at the same time, don't wish to delay it any further.
All right, court will set Mr. Powell for status on Dr. Proctor's expert report for March 28th. That'll be at 1:30. Who do you like next?
James Hancock.
I'm sorry, say that again, Mr. Schmidt.
James Hancock.
James Lee Hancock, CR 22354.
Correct, Judge. We're set for a pretrial today. I'm going to ask for an additional pretrial on Mr. Hancock, a short one, if the DA's office has no objection.
All right, being no objection from the state, the court will set Mr. Hancock for an additional pretrial hearing. Are there any discovery materials that we're lacking that we need to put on the record?
No, Judge, I don't believe that there are any lacking discovery materials. It's a matter of review and meeting with Mr. Hancock.
All right, the court will set Mr. Hancock for March 7th at 1:30.
Taylor Davidson.
Taylor Davidson, CR 2294.
Judge, set for arraignment on Mr. Davidson. Received the indictment's name spelled correctly, understands what he's charged with. We waive formal reading, enter a plea of not guilty, ask for a pretrial date.
All right, court will find that Mr. Davidson has waived the formal requirement of arraignment, will enter his plea of not guilty into the record, and will set pretrial on March 7th at 1:30. Mr. Davidson, you're becoming a regular around here. That's not good.
Joe Beatty.
Joe Junior Beatty, CR 22398 and CR 14450. Go ahead, Mr. Schmidt.
Judge, we're set for an arraignment on CR 22398. I've spoken with Mr. Beatty. He understands what he's charged with. His name is spelled correctly. We waive formal reading on that one as well. Ask that it be set for a pretrial date and ask that the motion to revoke be carried with it.
All right, court will enter Mr. Beatty's plea of not guilty into the record. Finds that he's waived the formal requirements of arraignment. We set this matter for pretrial on March 7th at 1:30. The court will carry the motion to revoke.
And Judge, I have a female writ and they're not in here yet, so that's all for me for right now.
Okay, thank you, sir. Do you have any other counsel, Jill?
Yes, Judge.
Are you ready on Mr. Manning?
Yeah, Mr. Mills.
Joshua Mills, CR 22-382 and 383 for arraignment.
Yes, Judge. My client has gone over copies of the indictment. He understands the charge against him. His name is spelled correctly. He makes a plea of not guilty and requests to be set on the pretrial docket.
Court enters Mr. Mills' plea of not guilty into the record in each charge. Court sets Mr. Mills then for pretrial March 9th. Do you have any conflicts on that date, Mr. Manning?
Judge, if I may just check real quick.
Sir.
Judge, I'll be here.
Okay. Each case is set at 1:30 on March 9th. Mr. Mills is in jail. Mr. Mills, if you make bail, then your court hearings will be in the morning at 9 a.m. Who's next, Mr. Manning?
Judge, I'm ready on Mr. Thompson.
Dalton Thompson, CR 2250, evading arrest for detention of the vehicle, CR 23-4, Class A misdemeanor, resisting arrest.
And Judge, what was the cause number on that first case?
The felony is CR 22-50, 3 zeros and 5.
And Judge, I believe that was reduced to a Class A misdemeanor when he went on probation to fleeing an officer and imminent danger SBI. And that was what the offense he was put on for, was that misdemeanor offense.
Okay, I see. All right, so this is gonna be a plea today?
Yes, Judge, we're gonna be taking care of both cases. And the state is also rejecting his remaining cases, so I'll take care of all of Mr. Thompson's business here in Van Zandt County.
Okay. All right, Mr. Thompson, raise your right hand. I'm gonna place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Sorry.
Thank you. Lower your hand. Your name is Dalton Garrett Thompson, is that correct?
Yes, sir.
All right, make sure you speak up loudly and clearly for me so I can hear you. Mr. Thompson, in CR 2250, you were on community supervision because on
July 9th.
July 21st, 2022, you appeared before the court and pled guilty to fleeing from a police officer with imminent danger, serious bodily injury, a Class A misdemeanor. The court heard the evidence on that day, placed you, assess your punishment at 1 year confinement in the county jail and a $2,000 fine. After conviction, the court suspended that sentence, placed you on probation for a period of 2 years. And it was during that 2-year period that the state filed a motion to revoke your community supervision. And in that motion, they alleged it appears to be 8 separate counts of ways they believe that you have violated your community supervision. Have you had enough time to review that motion to revoke with your attorney, Mr. Manning?
Yes.
And do you feel like you've had enough time to talk with him about that case, that you've had all of your legal questions answered?
Yes.
Is there anything about the paperwork that you've read over and signed in that case that you do not understand?
No, sir.
All right, in CR 23-4, you are charged by information with a Class A misdemeanor offense of resisting arrest, search, or transport that was alleged to have occurred on or about November 6, 2022. The Class A misdemeanor has a range of punishment if convicted to not more than 365 days in a county jail and a fine not to exceed $4,000. Do you understand that range of punishment?
Yes, sir.
I see that the plea agreement in this case is that you would plead guilty to the lesser included offense of resisting arrest, search, or transport. Your punishment would be recommended at 90 days confinement in the county jail, for which you would receive time served, and you would be fined $500, and you would be responsible for court costs and reimbursement fees. Is that your understanding of the plea agreement in that case?
Yes, sir.
Judge, if I may, the agreement was for 80 days with 80 days credit on the misdemeanor and 86 days with 86 days on the previous felony.
They're both misdemeanors. One's an MTR, it's 86, and the new one is 80 days.
Yeah, I just didn't go over that plea agreement. Yeah, because it's a motion or the. Mr. Manning, do you believe that your client's competent today to enter into these agreements?
I do, Judge.
Now, in CR 23-4, was he originally charged with a different offense?
No, Your Honor, he was originally arrested on, I believe it was an evading arrest with a motor vehicle. The state has rejected that charge and has charged him with this, with the evading, because he already had the motion to revoke up in your court. That's why it's here.
So where it says plea of guilty to lesser included offense, there's no higher charged offense. It should just say plead guilty to this offense.
Plead guilty to this offense. This was what was charged. There was a evading with a motor vehicle. The state has rejected that charge and has not did not charge that.
So I'm more than that, Judge. All right, Mr. Thompson, then with regards to the probation case, how do you plead to the counts alleged in all 8 counts in the motion to revoke? Are those counts true or not true?
True.
And are you telling me that those counts are true because in fact, what is alleged is in fact true? You're not saying that just to get a plea agreement, is that right?
Yes, sir.
In the new case, resisting arrest, search, or transport, how do you plead to that crime? Guilty or not guilty?
Guilty.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
And Mr. Thompson, has anyone threatened or forced you to make you feel like you had to plead true or guilty to either one of these cases?
No, sir.
All right, the court will accept the defendant's plea of true and the plea of guilt. Mr. Manning, any objection to state's evidence in either case?
No objection.
All right, the state's evidence supporting the plea in each case is admitted respectively, and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor, we would rest and close in each cause.
Anything further from the defense?
Rest and close.
Court's going to review the evidence. All right, the court has reviewed the evidence in each case. The court finds the evidence to be sufficient to convict Mr. Thompson of resisting arrest, search, and transport in CR 22-4. Court will follow the plea agreement, thereby convicts him of that Class A misdemeanor offense, assesses his punishment at 80 days confinement in the county jail with credit for time served, orders him to pay $500 fine, $270 court cost, and $15 in reimbursement fees. With regards to the probation case, the court finds that Mr. Thompson has violated terms and conditions of his community supervision. Court hereby revokes his community supervision, assesses his punishment at 86 days confinement in the Van Zandt County Jail with credit for time served. He's ordered to pay the balance of his financial obligations. Mr. Thompson, once you are released from custody, you need to make arrangements to discharge the fines and fees that your failure to do so will result in a warrant being issued for your arrest. Do you understand, sir?
Yes, sir.
All right, I'm gonna have you step over to Deputy Everett to be fingerprinted. Who's next, Mr. Manning?
Judge, I've completed paperwork on Mr. Gates, but we do have a time issue on his time credit. Miss Abney, I believe, is researching that as we speak. And then we also have paperwork on Mr. McGibbon I just got. We'll be executing that as well.
Okay, just let me know when you're ready.
Thank you, Judge.
I'm ready if you're ready.
I'm ready. You said that this is for writ on Amy Van Treese.
Correct.
All right, Ms. Van Treese,
Coming.
this is writ number WR 23-2. Go ahead, Mr. Schmidt.
Judge, just briefly, an announcement for the court. We had filed a writ requesting a reduction on Miss Ventry's bonds. I think she's been in custody since November 7th. Not at 90 days yet. It's not a 90-day writ, but we had met with the DA's office and reached an agreement concerning reduction of her bonds and submitted an agreed order for the court. Basically, in a cumulative amount, reducing her bonds from 200,000 to 100,000. And if the court would like some testimony, we can proceed with that.
Does Ms. Van Treese have any criminal history that the board should consider in reducing bail?
Judge, based on my communications with Ms. Van Treese, she's been arrested one time for driving without a license.
Judge, that appears to be correct.
Okay. Any other 17, 15 bail factors that either state or defense believes that the court should be aware of?
Judge, I'm unaware of any. I believe that this is the first rodeo for Ms. Van Treese. None of those factors are in my, based on my knowledge, a consideration or a concern. The state may have a different opinion.
Anything from the state?
Judge, the only things that the state would bring to the court's attention is that Ms. Van Treese does have appears to be 2 co-defendants. We would ask that just as a condition that she not have contact with co-defendants. I'm unaware of their relationship at this time, but considering she is charged along with a Carl Edward Long Jr. and a Warren Clay Pruitt, we would ask that she have no contact with them. Beyond that, we don't believe that there are any other factors the court need to consider.
And Judge, I can't tell you that Mr. Long is the spouse of Ms. Van Treese. My understanding that she intends, if released or if she makes bond, to live with her sister, right? With her sister. And Mr. Long, I believe, is in custody at this point.
He is, Your Honor.
Mr. Schmidt, do you have any objections to the proposed conditions requested by the state?
No objections to those, Judge.
Okay, all right, then the court will grant the agreed order on writ of habeas corpus. We'll set cash or surety bond at 25,000 for hindering apprehension of a felon, 25,000 cash or surety for interference with public duties, and $50,000 cash or surety for manufacture delivery of a controlled substance of penalty group 1, 4 grams, but less than 200 grams. And the court will assign conditions of pretrial release, including for Ms. Ventries not to have any contact with the co-defendants named by the state.
Thank you, Judge. And I believe that's all I have on your docket today. May I be excused?
Yes, sir, you may. Thank you.
Oh, yeah. You'll call me first.
Yes. One was the revocation, one was the. Hey, did you my text on? Okay. Yeah, question. That's fine. It's.
They said that blind guy didn't have them, that arrested him with no warrant. Went back there, sure enough, it's up there in the bedroom file. But the dispatcher that ran him, I guess ran him wrong and shows no warrant. But they look in the system, sure.
But it wasn't.
It's there.
Okay,
All right, this is cause number CR 21304, State versus Matthew Ryan Peters for docket call. Mr. Ashmore, any announcement on docket call?
Judge, we request to be set for trial. We appreciate all the time the court and the state has provided. We've not reached a resolution that either side can agree with, despite multiple discussions between the state and I and conversations with my client. So we're just going to ask the court to set this matter for trial.
All right, can either the state or you, Mr. Ashmore, tell me what the plea offer was that was rejected and what the counter offer was that was rejected, so we'll have this on record.
The plea offer is 15 TDC, and there's been multiple discussions about whether or not he's eligible for any kind of intensive supervised probation or safe P. Mr. Peters has been sober since 2020. Some of that time has been inside, but when he was out, he was also sober and has remained so. He did take a TDC to just finally be done with a case in Collin County.
That's okay. That's okay. I don't want to hear any of that. I just want to know what is the offer, so that if the Friday before trial comes and he's wanting to take an offer, I want to know what the baseline is. So he's rejected 15. Mr. Peters, you understand that by not resolving your case today, and you don't have to accept the state's offer. The state doesn't even have to make you an offer, but you understand that since you are not able to reach a plea agreement with the state today, that the court's not going to entertain a plea bargain after today's date. You understand that?
Yes, sir.
Okay. All right. The court will place Mr. Peters on the trial docket, and we'll place him on the next available, which will be next week, January 30th. Mr. Peters, you will not go to trial that week, but you'll get on the court's trial list, and you'll work your way up to the top. Once your case is in the top 10, then you and Mr. Ashmore will be liable for appearing and being ready. Okay.
Okay.
All right. All right. We'll see you. We'll see you soon.
Thanks.
See you soon. Thank you. Mr. Peters, I'll come visit you as soon as I can. Thank you, sir. Thank you, Judge.
Thank you, Mr. Ashmore. All right, Mr. Manning, you ready?
Yes, Judge.
Who are you ready on?
Ready on Mr. Gates.
All right, Mr. Gates, if you'll come on up, sir. This is cause number CR 21217, State of Texas versus Cody Eugene Gates. Mr. Gates, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand. All right, Mr. Gates, you're here on a motion to adjudicate guilt. The state of Texas filed a motion to adjudicate your guilt on December 13th of 2022. Prior to that, on April 14th, 2022, you appeared before the court, pled guilty to theft of property, a state jail felony offense. Court heard the evidence that day, followed a plea agreement that you reached with the state. Court deferred to finding of guilt and placed you on community supervision for 3 years. The state then filed a motion indicating that they believed you violated your terms and conditions of community supervision. They alleged 6 separate counts of ways that they believe you did so. And that is why you are here today. Have you had enough time to go over that motion to adjudicate with your attorney, Mr. Manning?
Yes, sir.
And are you happy with Mr. Manning as your attorney?
Yes, sir.
Do you feel like you've had enough time to talk with him about this case and have all of your legal questions answered?
Yes, sir.
Is there anything about the paperwork that you've read over and signed today that you do not understand?
No, sir.
It appears that the plea agreement today that you've reached with the state is that you would plead true to all of the counts alleged, and the state would recommend that the court adjudicate you today. That means find you guilty, and that the court revoke your community supervision and assess your punishment at 6 months confinement in the state jail division of TDC in order you to pay the balance of your financial obligations, and you would receive 49 days credit towards your sentence for the time that you spent in jail on this cause. Is that your understanding of the plea agreement and what you're asking for to approve?
Yes, sir.
All right. Mr. Manning, do you believe Mr. Gates to be competent to enter into this agreement?
He is, Judge.
You explained to him his rights as they pertain to this motion.
I have.
All right, Mr. Gates, as to counts 1, 2, 3, 4, 5, 6, how do you plead? Are those counts true or not true?
True, sir.
Are you telling me that each one of those are true because in fact what is alleged is true? You're not just telling me that so you can get a plea agreement?
No, sir, it's true.
Okay. All right, court will accept the defendant's plea of true at this time. Mr. Manning, any objection to the state's evidence?
No objection.
State's evidence is admitted and the court takes judicial notice of the defendant's judicial petition. Anything further from the state?
No, Your Honor, read rest and close.
Anything further from the defense?
No, Judge.
All right, then based on the evidence presented, the court finds that Mr. Cody Eugene Gates has violated the terms and conditions of his community supervision. Court follows the plea agreement, adjudicates his guilt, revokes his community supervision, assesses punishment at 6 months confinement, state jail division of TDC, orders him to pay the balance of his financial obligations, and awards him 49 days credit towards his sentence for the time that he spent in jail on this cause. Mr. Gates, once you're released from TDC, you need to report to the courthouse and make arrangements to discharge your fines, court costs, and reimbursement fees. If you don't do that, then the court is gonna have to issue a warrant for your arrest. We'll have to go through this all over again. Okay.
Yes, sir.
Okay. All right. Step over with Deputy Everett to be fingerprinted. All right, Mr. Manning, who do you want this?
Ready on Mr. Travis McKibben.
Travis McKibben, CR 22 at 22. Set for plea today, is that correct?
That's correct, Judge. This is, Mr. McKibben apologized for being late last week. He was right behind us as we finished up, but he got here, got himself turned in and has been sitting here ever since. He's grateful for the opportunity to go forward.
Okay, and I don't have the plea papers here. Can you remind me what the plea agreement is?
Yes, Judge. It's for a charge of possession of controlled substance, penalty group 1 less than a gram. That charge was indicted and the date of offense was July 10th, 2021. As I said, it's a state jail felony. He's agreed to take 8 months state jail with a fine of $1,500, restitution amount of $180, court costs $290, and reimbursement $35. Additionally, Judge, he has 43 days credit. And I believe that composes the entirety of our agreement.
All right, Mr. McKibben, raise your right hand. I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
All right, thank you. You can lower your hand. All right, you are Travis Glenn McKibben. Is that
Yes, sir.
And Mr. McKibben, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Manning. Are you pleased with Mr. Manning as your attorney?
Yes, sir.
Do you feel like you've had enough time to talk with him about your case?
Yes, sir.
Do you have any questions about the paperwork that you signed today?
No, sir.
All right, Mr. McKibben, you are charged by indictment with a possession of controlled substance at penalty group 1 less than 1 gram, a state jail felony. The range of punishment for that offense is not less than 6 months confinement in prison and not more than 2 years confinement in prison, and a fine which cannot exceed $10,000. Do you understand that full range of punishment?
Yes, sir.
And you heard what Mr. Manning said about the plea agreement, about it being 8 months and the fines and the court costs. Is that your understanding? Is that the agreement you made with the state?
Yes, sir.
Mr. Manning, do you believe that Mr. McKibben is competent to enter into this agreement?
Yes, Judge.
You explained to him his rights as they pertain to this case.
I have.
Mr. McKibben, then how do you plead to possession of controlled substance penalty group 1 less than 1?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty today?
No, sir.
All right, the court does accept the defendant's plea of guilt. Mr. Manning, any objection to state's evidence?
No objection to state's one, Judge.
State's 1 is admitted and court takes judicial notice of the defendant's judicial confession. Anything further from the state,
No, Your Honor, we'd rest and close at this time.
from the defense?
Welcome, Post Judge.
All right, and because I don't have the plea papers here, Mr. Woodwhite, can you give me the summary of evidence to support the plea?
Yes, Your Honor. On the date in question, the sheriff's office pulls over the defendant and his wife for expired registration. The defendant has a Class C warrant, and because of this, the sheriff's office asks for consent to search the vehicle, which the defendant gives. In a purse in the center console, the sheriff's office finds what they believe to be methamphetamine. The defendant states that it is meth and that he gave them to his wife to hide, and then claims that the lab tests at 2.76 grams of methamphetamine.
Thank you, Mr. Woodwhite. And is there a lab included in the plea, Mr. Manning?
Yes, Judge, it is part of the plea.
All right, great, thank you. All right, anything further, Mr. Manning, from the defense?
Nothing from-
All right, then based on the evidence, the court finds that there is sufficient evidence to convict Mr. McKibben of this offense. Court will follow the plea agreement. Court hereby convicts Travis Glenn McKibben of possession of a controlled substance penalty group 1 less than 1 gram. Assesses punishment at 8 months confinement in state jail division of TDC. Orders a $1,500 fine, $180 restitution, $290 court cost, and $35 reimbursement fees. And the court awards Mr. McKibben 43 days credit towards his sentence for the time that he is spent in jail on this cause. So, Mr. McKibben, if you'll step over with Deputy Everett to be fingerprinted, good luck to you, sir.
Thank you.
Mr. Manning, I have a note on the docket that said that you had a writ set today, but my note indicates that your client, Jacqueline Smith, bonded out on January 10th.
That's correct. I thought we pled her on the 10th.
Yeah, I can't remember. Maybe so, but it just mine says bonded out on 10. Either way, you're non-suiting your writ, correct?
That's correct, Judge.
All right, can you give me an order to non-suit so we can take that off the books?
Certainly, Judge. I thought by her pleading that would resolve it, but if you'd like, I can send a order non-suiting.
I don't know. I'll have to ask the clerks. That's a civil filing versus a criminal filing. I'll see what my coordinators say about that. If not, I'll let you know. We'll get one.
Absolutely, Judge. I did also had a writ on Mr. Lyons.
Okay, are you ready on him?
Yes, Judge.
All right, to Keithy and Lyons. CR 22-152, CR 22-76. Go ahead.
Judge, I'd like to call my client.
It's all right, Mr. Lyons, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
All right, thank you. During your testimony, just make sure you speak up loudly, clearly, so I can hear you, and my court reporter can take down what he has. Go ahead, Mr. Manning.
And Judge, I'd ask that his testimony be given for the limited purposes of hearing on bond and whether or not it's reasonable or not at this time.
That request is granted.
Mr. Lyons, how long have you been in jail?
Approximately 8 months.
And if I was said that you've been in for 235 days, that comport with what your understanding of your length of stay is?
Yes, sir.
Okay, and you're currently sitting on 2 cases on bond. Can you tell the court what the bond amounts are that are for those 2 cases?
Unlawful use of a motor vehicle for $1,500 and burglary habitation for $50,000.
Okay, and have you been able to make those bonds?
No, sir.
Okay, have you attempted to make those bonds?
Yes, sir.
Okay, and do you have any assets that you could put towards those amounts?
I'm currently trying to file my income taxes so that I can. I've just gotten my sister's contact information to try to give her a power of attorney.
And if you were to receive a reduction, would you be able to make bond and continue making your appearances with this court?
Yes, sir.
Okay, and what type of reduction would you need to be able to do that?
Somewhere in between 5,000 to 10,000 if possible.
And that's total between the two cases, is that correct?
Yes, sir.
Okay. And if you were to make bond and if the judge were to grant that bond reduction, would you be able to continue coming to court?
Yes, sir. I will be living right here at 379 Van Zandt County Road 2106 is literally walking distance.
Okay.
From the,
And that answers two of my questions, which is you'll be housed here, is that correct?
oh, yes, sir.
Okay, and will you have transportation or be able to, as you said, walk to court if necessary?
Yes, sir. My grandfather lives right next door to me.
Do you also have a job awaiting you when you get out?
Yes, sir. I have two waiting. I have one at Texas Wing Construction on 19. And I have one in Madex and Terrell.
And would that allow you to pay for any reporting fees, pretrial release fees, that type of thing, as you're on bond?
Yes, sir.
Okay.
Both of them are trying to start me out at 18 an hour.
And would you agree to abide by whatever conditions the court would set on you to ensure your appearance on its docket?
Yes, sir. I intend to appear.
Your Honor, I pass the witness this time.
State, any questions?
Judge, no questions at this time. We believe that the court will make the right decision on this.
Judge, if I may just briefly recall my client.
Go ahead.
Mr. Lyons, you have never received any bond jumping charges, is that correct?
No, sir.
Okay, and you've never failed to appear to court, is that correct?
No, sir.
And additionally, you don't have any history of violent offenses that would put the court in danger if you were to get out and commit a violent offense, is that correct?
No, sir. I don't.
Okay, I pass the witness, Judge.
Okay, all right, the court will take it under advisement and I will issue a ruling at the end of
Yes, Judge.
the. And I believe that Mr. Lyons is already set for trial, correct?
That is correct, Judge.
All right, thank you.
Judge, just while we're here, Mr. Lyons was just indicted on Friday on one of the, I believe he already has a personal bond on the charge we indicted. I will remind the court that our agreement is that Mr. Lyons is planning on going open on the newly indicted unlawful possession of a firearm by a felon, just for the court's information in making this determination. So as soon as we can get him a court date on going open to, I believe, the jury for punishment, that is the intention, the intended resolution to all of this.
Okay, all right, thank you.
Judge, I believe that concludes my business. May I be excused at this point?
Yes, sir, you may. Thank you. Appreciate your help today. State, stand by for just 1 second.
Appreciate it.
Try it one more.
Return.
Yeah.
Yes,
Doesn't show on the list, but maybe. Patty's was in place.
Deputy Everett.
Yes, sir.
All right, so the only case we have left is Brett Turnage. Mr. Wood's not here. He's not logged in. and we don't have any updates from regarding his weight. Will you check with jail staff to see if there's any issues or concerns the court should be aware of regarding Mr. Turnage that we need to address? That'll help me determine whether I reset his case for like Thursday, or if I can reset it to March.
Okay, stand by.
Thank you. Yes, sir.
They say that he is very cognizant of what's going on. He's been taking his meds, but he still thinks these things in his head are real, and he's not arguing with the psychologist, not gonna argue with him. Like he says, he knows you think it's real, but he still firmly believes when his stuff in his head's real.
Okay, so there's no health concerns, there's no concern of violence, anything of that nature. Okay.
No.
All right, what we'll do is we'll just reset Mr. Turnage. Let's set him for March 28th. We'll set him for March 28th for a status. And Ms. Tabraham is going to try to get an update from the hospital system to find out what our weight is on him, kind of see where his priority is, and then I'll have her email that to Mr. Wood and also to the state.
Yes, Judge, I spoke with Ms. Tabraham. She said she reached out late last week and just hadn't heard back. So hopefully we'll get that soon.
Right. Okay. All right. Well, that does look like that is all of the cases for this afternoon. So I appreciate you, prosecutors.
Thank you, Your Honor.
Thanks, Judge. Stay dry.
Y'all have a good day, and we'll talk more about that special field trip in February.
Are we planning
Okay.
on doing Thursday still in the courtroom, Judge? As of right now?
We'll check the forecast. Let's see. Forecast says here in 10 days. Because I'm going to start setting my cases based on whether it's going to rain or not rain, you know? So Thursday is supposed to be what?
You know what? That's the bottom.
Sunny and 51. So we'll probably plan to be here.
Sounds good.
Good.
Unless someone comes in here and busts up the courtroom and decides they have to fix the rain cloud in the scene. So I don't know. I wish I could give you all the answers.
Sure.
We're all playing by ear and that's fine, Judge.
Play it by ear. We'll plan to be here and play it by ear.
Thank you,
Sounds
Judge.
good. Thanks, Judge.
So, yeah.